Okay, so at this time,
I think some other folks are coming in, Mr. Chair. I think a lot of them are actually possibly your constituents who are coming in, folks you may recognize.
Yes, I do. Thank you.
From our neck of the woods
right.
down south.
As we transition here, I think it's important to thank everybody that traveled from such great distances to be here today. I know that this committee really appreciates participation and engagement from our citizenry, and today we see that carried out here today in a big way. So with that, let's continue moving forward. Next bill up is Senate Bill 588. Mr. President Pro Tem, whenever you're ready, you have the floor.
Thank you once again for your indulgence, Mr. Chair, as well as Mr. Vice Chair and esteemed colleagues of the Labor Committee here in the State Assembly, I should say. Senate Bill 588 empowers the Labor Commissioner of California with additional tools to help fight the problem of wage theft in our state. Now, wage theft takes many forms, including stealing workers' wages by paying them less than the minimum wage, shaving hours off workers' paychecks, as well as failing to pay for overtime as required by California state law. Now, wage theft, the reality is an epidemic. A UCLA study found that in Los Angeles County alone, workers have had more than $1 billion, and it's not 1 million or 10 million or 100 million, but rather $1 billion stolen from them each year. And in a report published last month by the Center on Policy Initiatives, it was found in a survey of 337 restaurant employees, 77% of them have been victims of wage theft. That's 1/3 of them who were surveyed, said it happens quite regularly. Existing labor laws simply are not effective as they could be. In another study by the UCLA Labor Center and the National Employment Law Project, the data showed that 83% of workers who actually win a wage claim never actually see a dime. Now, again, these are cases that have been adjudicated, and 83% who actually have won their claim against the employer for wage theft never see a dime. The wage theft problem is compounded by our economy, which increasingly relies upon low-wage service sector jobs, workers for temporary work. Wage theft disproportionately impacts vulnerable workers in our state, including low-wage workers, women, people of color, as well as immigrants. Now, SB 588 targets specifically the bad actor employers. We have worked very hard with all the stakeholders across the board. There was a version of this measure that moved forward last year. I want to commend the author. He worked tirelessly hard, Mr. Stone. We have crafted this measure in a different direction, where we've worked with all stakeholders to target on those individuals who are actually bad actors with stronger enforcement options. This means only those employers who have been found guilty, again, let me underscore and emphasize, only those employers who have been found guilty of stealing workers' wages, who then refuse to pay what they owe, will face severe consequences under SB 588. This bill requires a business that has not paid or made arrangements to pay an outstanding judgment against them within 10 days of the final decision. They must acquire a wage bond of $150,000. If the business fails to comply, the employer is subject to a stop order and a lien at the Labor Commissioner's discretion. So in short, what we do is we empower the Labor Commissioner by giving her more teeth. SB 588 also gives the Labor Commissioner the authority to hold individual business owners accountable for their debts to workers by allowing the Commissioner to use existing authority under the Bureau of Field Enforcement to apply wage claims. This improves collection methods by the Labor Commissioner, greater flexibility in choosing how to secure the assets of bad actors. The committee analysis, Mr. Vice Chair, reflects recent amendments taken at the request of the Chamber and other members of the employer community. We have been working again very closely with all those individuals who have significant concerns with SB 588, and we share the collective goal this is the most important part, we all share the collective goal of targeting bad actors. So the issue is not specifically, is wage theft in dispute? It's not in dispute. The question is how to go about it in such a manner that we can recover the assets stolen by bad actors, so we can make sure that we can get workers who, the great American way, you come to this country, you work hard, you should be paid for what you've done. Make sure they're compensated for their hard labor and for their hard work. Businesses that play by the rules will benefit from SB 588 because we have bad actors, again, they're unscrupulous and undercut those good businesses, which, by the way, are the vast majority of the businesses in the state of California. With that, Mr. Chair, as well as Mr. Vice Chair, as well as colleagues, this is a very good bipartisan measure. I respectfully ask for your aye vote.
Thank you very much. At this time, we'll hear from your first witness.
Good afternoon, Assembly members. My name is Tia Kuntz, and I'm the Legal and Policy Research Manager at the UCLA Labor Center. We are the office that actually conducted the studies that were referred to by the Pro Tem. Wage theft is widespread and systematic, and I know that the Pro Tem has mentioned a few of the statistics. Some of them bear repeating. In any given week, 8 in 10 low-wage workers in LA experiences a violation of one of our most basic labor protections. So that's 30% are making less than the minimum wage. 80% are working overtime and not getting paid an overtime rate of pay. Another 80% are working straight through their meal and rest breaks. And compounding matters, as the Pro Tem has already articulated, the great secret of this practice area is that, and what this bill seeks to address, workers are not able to collect on what they're owed, even after they've proven that they're owed this money. So my office analyzed all 160,000 claims filed with the state's labor commissioner between 2008 and 2011, and we found that workers who obtained a final judgment, a court order for unpaid wages, stood just a 17% chance of collecting a dime. So 83% had nothing to show for their hard-earned work. Their employers are bad actors, okay? So they've ignored every opportunity to settle. They lost their hearing if they bothered to show up at all. And now they're avoiding payment by transferring or hiding assets in the name of somebody else or simply refusing to pay, right? 63% are no longer operating by the time a worker actually obtains her final judgment, which is leaving her holding a piece of paper against a company that doesn't exist anymore. Judgments are exactly that, so that you understand they are pieces of paper. What translates a moral victory into food on the table is actually getting employers to pay on these judgments and bringing these bad actors to the table early and often. And this bill is one of the smartest policy solutions that I've seen to address this problem, and it does so in 3 key ways. So just as the Pro Tem has just articulated, it targets deadbeat employers. It targets these bad actors. Employers who fail to pay a final judgment for unpaid wages, they're likely to do it again. They don't care, or they're systematically undercapitalized and may not be able to make payroll at all. They'll have to post a bond with the labor commissioner in the amount of $150,000 as insurance to future employees that even if they disappear, those employees can collect from the bond company. In the event that they fail to pay a final judgment and then fail to post a bond, this is their third bite at the apple, and another worker comes, the labor commissioner has every reason to believe they're a fly-by-night operator. In that instance, the bill authorizes the labor commissioner to file a lien on that business's property as soon as the workers file a claim against it, rather than having to wait until the end of the process, at which time 63% of those employers are going to be out of business and their assets unavailable. Okay? These 2 tools work together to create an incentive for outlaw employers to pay what they owe and protects their employees in the future from any disappearing acts. So that's number 1, targeting deadbeat employers. Number 2, this bill addresses abuses of our corporate laws that enable bad actors to get away with this. So in the first, it holds individuals accountable when they cause a violation of basic wage laws. This is actually current law.
Your time is up.
Oh, pardon me. Okay.
You can wrap it up, please.
Absolutely. I just do want to articulate 2 things really quickly, one of which is that this is current law, and I know there's been some concern expressed about the application of this law to managers who are not actually causing a wage violation. The law is intended to make sure that workers whose employers are hiding as managers, which is quite frequent in low-wage industries, are able to collect. And in the second, this law actually is quite distinct from 1897, which was intended to address the rise of staffing and temp agencies. Instead, it targets industries that almost exclusively operate through contracting and subcontracting, which are property services and long-term care, which consistently frustrate enforcement. As a worker who wins a judgment against her immediate employer, that employer probably has shallow pockets and is undercapitalized. So the idea is to extend what's available in construction and garment, the other 2 industries in the state that operate through contracting and subcontracting, to allow the worker to go up the food chain where the pockets might be able to actually pay. Thank you very much for your time.
Thank you very much. Next witness, please. Por favor.
Buenas tardes, mi nombre es Silvano Pérez y aquí estoy de nuevo en la lucha. Y bueno, yo anteriormente trabajé para una compañía llamada Excel.
Good afternoon. My name is Silvano Pedres. Here I am again in the fight. I worked for a company.
Una compañía llamada Excel y trabajaba yo los 7 días de la semana de 9 a 10 horas sin descanso.
Named Excel, and I work 7 days a week, 9 to 10 hours.
Cuando yo quería pedir un día de descanso o un permiso, no me lo daban. Simplemente me decían, o quieres el permiso o ya no hay trabajo para ti, como una amenaza.
When I wanted to ask for a day off, they told me either you work or you can just go, as a threat.
Y aparte nos trataba tan mal que, la verdad, a veces yo me sentía, en mi caso, como si fuera un esclavo. Un esclavo de la era moderna, pero un esclavo. ¿Por qué? Porque era muy poco el pago, porque ganaba menos del mínimo y era mucho lo que yo trabajaba.
I felt I was treated so poorly that I felt I was like slave labor because they just kept me working and they wouldn't give me no time.
Y cuando a la hora de que nos pagaban, a veces nos pagaban con cheques sin fondos. Y la verdad, con lo poquito que yo ganaba no me alcanzaba para pagar ni mis biles y yo a veces tenía que conseguir prestado con mis amigos para poder llevarle un plato de comida a mis hijos, porque era muy poco el dinero que ganaba.
When they did pay me, they paid me with checks with insufficient funds, and I didn't have enough money to pay my bills, to pay food, to take food home on the table.
Ya que a mí no se me pagaba ni overtime, ni descanso, ni nada.
I wasn't paid overtime, and I didn't get any breaks.
Y yo creo que hoy estoy aquí para apoyar esta ley, la SB 588, porque no es justo que nos estén robando nuestros sueldos estas personas.
I'm here to support 588 because I don't think it's fair for people to be stealing our wages.
Ya que esto creo que nos los ganamos con nuestro esfuerzo. Y mientras que estas personas se llenan la bolsa con nuestro trabajo, yo creo que lo único que queremos es que nos den nuestro sueldo que hemos ganado y sí, por nuestro sueldo que hemos ganado y que nos den un trato digno.
We earned this with our hard efforts, and I think that we should get paid our wages. That's what's fair.
Ya que estas compañías que trabajan fraudulentamente no nada más nos roban a nosotros el sueldo, también le están robando al gobierno.
Because these companies that are committing fraud against us isn't just against us, but it's also the state.
Ya que ellos no reportan, yo creo, todo lo que en realidad están ganando en dinero.
Because they're not reporting all of the earnings that they have.
Y es por eso que yo el día de hoy estoy aquí, vengo a pedirle su apoyo, porque esto no nada más nos beneficiaría a nosotros como personas para tener un trato digno y una mejor calidad de vida, sino que también le beneficia al gobierno, yo creo.
So that's why I'm here today, to ask for your support, to be treated with dignity, and not just only to be treated with dignity, but also because of how it's affecting the state.
Bueno, eso es todo. Gracias.
Thank
Y
you.
que Dios los bendiga.
God bless.
Thank you very much. Do we have another for testimony?
Thank you, Renee Bayardo, SEIU California. We're one of the co-sponsors. Ask for your support.
Okay, and also those wishing to add their support to the bill. Go ahead.
Mr. Chair and members, Caitlin Vega for the California Labor Federation. We think this is an extremely important bill to ensure that low-wage workers get paid for the hours that they work. Thank you.
Thank you. Your name, organization, and position.
Steven Sepulveda on behalf of the California Immigrant Policy Center, in strong support of this bill.
Thank you. Please go ahead and come forward.
Hi, I'm Alexandra Sa from the Koreatown Immigrant Workers Alliance. We're one of the co-sponsors, and of course, we strongly support this bill.
Thank you.
Daniela Urban, Center for Workers' Rights in Sacramento, in support.
Thank you.
Mariko Yoshihara with the California Employment Lawyers Association, in support.
Thank you.
Joseph Delgado with ACE, representing 10,000 members statewide in support of SB 588.
You.
PYWD California Partnership, Coalition of Statewide Anti-Poverty Organizations in support.
Thank you.
I'm Wanda Cleveland, and I strongly support SB 88.
Thank you.
Christina Rechica, Sacramento resident and ACE member, in support.
Thank you.
Anel Flores with the Maintenance Cooperation Trust Fund, in support.
Thank you.
Denise Davis, ACE. I'm in support.
Thank you.
Stuardo Mazariegos, ACE, in support.
David Sharples, Richmond resident, member of ACE, in support.
Christy Akeem, member of San Francisco ACE chapter, resident of San Francisco, strongly support this. Thank you.
Giovanna Fajardo, in support.
Melvin Willis with ACE, also Richmond resident, and strong support.
Carol York, Child Development Assistant for the Head Start, also in support.
Jeanette Stevenson with Sacramento Mighty Oaks, chapter leader, in support.
Alia Phelps, resident of Oakland, member of ACE, in support.
Renee Amador with the Wage Justice Center, in strong support.
Grace Martinez with ACE, resident of San Francisco, in support.
Thank you very much. Any others wishing to add on in support? Seeing none, those in opposition or with concerns, please come forward. Up to 3 may speak.
Good afternoon, Mr. Chair and committee members. Jennifer Barrera on behalf of the California Chamber of Commerce, and we have not taken a formal position on this bill. We are listed in concerns. The reason why we don't have a formal position yet on the bill is because, as Senator De Leon mentioned, that we have been working together with the author and the stakeholders to try and address this problem. It is not in dispute that there is wage theft out there, and we agree that wage theft should be dealt with. And we believe that 90% of this bill addresses the bad actors and goes after those companies or employers who choose not to pay their employees wages that they are owed. And so we are very supportive of several provisions of this bill that actually are directed at those bad actors. Our concern is with 2 provisions of the bill specifically. One is dealing with the expansion of personal liability onto any employee who causes a violation to occur. This is in an existing labor code section 558, but it's limited to penalties being assessed by the labor commissioner against any employee acting on behalf of the employer that causes a violation, and it's limited to one specific chapter of the labor code. This bill proposes to expand that to things that we believe are outside of an employee's control and could expose them to personal liability. For example, the bill specifies that they could be liable for waiting time penalties, which is 1 day of wages up to 30 days, and could be pretty significant for a shift leader, supervisor, somebody who actually doesn't have direct control over issuing payment to the employee, but nonetheless under this proposal could be named personally in a lawsuit and be held personally liable for those unpaid wages, despite the fact that they don't have control. A lot of case law out there all focuses on the control of the individual as to whether or not they will be personally liable for the unpaid wages, and we believe that there needs to be some type of clarification included in that section to specify that the employee who you're seeking to hold personally liable did have some type of control to issue the payment before they're held personally liable for those unpaid wages. The other section that we're also concerned about is the expansion of joint and several liability to employers for property services contracts. Unlike 1897 that was passed last year, there was a small business carve-out in 1897 that it was not applicable to smaller employers with 25 employees or less, and they had to be contracting with at least 6 workers at any particular time. We believe those types of protections should be included in the bill. A lot of these property services contracts are done outside the knowledge or view or control of the employer or business who's contracting for them, and so we don't want to expose that liability to these small employers who didn't have a true opportunity to prevent the wage violations from occurring. Also, even we appreciate the intent of the bill, the provision on this part to encourage businesses to do responsible contracting and make sure that they're hiring a responsible contractor. But even even if they do that due diligence at the front, they still could be exposed to joint and several liability on the back end without an opportunity to cure those violations before they're taken into civil litigation, et cetera. So we are hopeful that we can reach a resolution with Senator De Leon on this issue. As we stated, we have been working together with them, and we're hopeful that we can come to a position where we don't have any concerns anymore on this bill. So thank you.
Thank you very much. Please go forward.
Mr. Vice Chair, Chris McKaylee on behalf of the Civil Justice Association of California, and I'd just like to reiterate the points that Ms. Pereira indicated, and we completely agree, as we did in the last couple of years when we battled in both houses regarding the prejudgment wage lien legislation. We're very thankful that Senator De Leon has taken a different tact, which is to empower the Labor Commissioner as a third party, and we believe that that is the right approach. If you just briefly look at page 17 of the bill, line 2 is the reference to section 588 and the individual liability concern. So we'd seek modification there. The joint and several liability and some sort of cross-reference or the ability to utilize some of the language from last year's AB 1897 is in section 9 of the bill on page 16, line 1. And the final issue that we have discussed with Senator De Leon and his staff relates to granting additional discretion to the Labor Commissioner on page 10 in section 4 of the bill, lines 25 to 27. This is where the Labor Commissioner can order a bond to be not less than $150,000. What we would specifically like is that it would be some sort of an amount determined by the Labor Commissioner, but in no case shall exceed the $150,000 to recognize particularly small businesses and their ability to obtain a bond of that sort of size. And so where many other provisions of this bill grant discretion to the Labor Commissioner, we would like to see the Commissioner have that similar discretion as it relates to the amount of that bond. Thank you.
Good afternoon, Mr. Chair and members of the committee. Javier Gonzalez here on behalf of the California Restaurant Association. We don't disagree that employees should be paid for what they're owed for their work. However, we do have some significant concerns, as outlined in the coalition letter provided by the Chamber of Commerce. So we're looking forward to working with the author of the bill and resolving those significant concerns. Thank you.
Thank you. And those wishing to add on with opposition or concerns?
Dane Hutchings with the California Grocers Association. Align my comments with my colleagues. Look forward to working with the author and staff. Thank you.
Thank you. Any further wishing to add on? Okay, with that said, let's open it up to the committee. Okay, there's a motion and a second. Are there any comments? I'll just note, go ahead.
To the Chamber of Commerce.
The Chamber rep could come.
The representative. You are working with the author to accommodate these changes.
Yes, we're trying to reach a resolution.
As of today, those changes have not happened.
Not yet.
Where to our Vice Chair, I hope you know, where does this bill go next?
Judiciary.
So this goes to Judiciary, and then does it go to the floor?
No, appropriations, yeah.
To appropes? Okay. Without resolution of these three matters, does your concern turn into opposition?
I won't know until that time, but I will certainly apprise members of our position if it changes. We're hopeful that we won't reach that point of having to change from opposition. Our hope is that we can remove any concerns on this bill.
And how would you categorize the momentum toward a solution?
I think the author and his staff have been working in good faith with us. As a lot of the committee notes, there's been amendments that they took today at our request and the coalition's request. So I definitely think that we're all working in good faith.
Thank you.
Mm-hmm.
And if I may, through the chair, for Mr. Patterson, I think that there was a version, I can't articulate exactly verbatim the version from last year. It was Yeoman's Tribe by Assembly Member Mark Stone. If we can recall, during that time period, it was sort of like DEFCON 4, if you will, with the Chamber and the other stakeholders on the business side community. We tried decisively a different tact, if you will, given the fact that I think across the board, on both sides, there was clear agreement that wage theft is an epidemic. It's happening, and it's costing us billions of dollars, taxpayers, the ability to take care of their families. So therefore, tactically, and there's been a lot of constructive dialogue on both sides, the chamber side and the side of the workers, that the tone and tenor has been decisively very different. We've narrowed down a tremendous amount of differences. Obviously, we have judiciary as well as approach before it gets to the floor. Dialogue is continuing in a very constructive manner, and it is dramatically different from last year's version. At least the atmosphere, if you will, obviously the content, but the atmosphere surrounding the measure itself. Because last year, obviously, it failed to pass the floor on the Senate side last year.
And if I could also comment in relation to my colleague from Fresno, I also agree with the significance of the issue and the urgency of the issue. I think just the question really is, can we come together in what many different parties agree with different points of view as to a solution that many could agree to. And so while I'll be voting in opposition to this today,
perhaps you lay off altogether. Maybe you lay off.
I'll vote no today, but
okay.
but perhaps I have no
suggestion. That's all.
No shortage of the ability to be able to vote no from time to time, but it is certainly something that I see myself with the right compromise. I think it's something that I can vote for in the future. So I just wanted to acknowledge.
Sure. No, I'm very respectful of that, Mr. Vice Chair. I think, again, just to reemphasize, there's been a lot of hard work on both sides, and it's very clear that this is a real, true epidemic. And what we don't want to do is throw a wide net and capture individuals unnecessarily going through an onerous process that prejudices the good actors. And it makes it much more difficult to roll up your sleeves and go forensically deeper into the weeds to sort of, as our witnesses have said, really hone down and target on those individuals who are the bad actors and, quite frankly, continuously behave in such a manner that they go underground, they change their name, license number, they reappear all of a sudden, they continue those bad practices, which is really bad for the business community altogether because they are undercut, if you will, with very cheap labor because they're stealing wages from these hardworking men and women, and oftentimes these are from the lowest economic strata. So what happens? A mother or father, or especially a single mother, has to do everything within her power to take care of her family. And if she has to go on some type of subsidy because her wages have been stolen by a bad actor, that's a reflection on the whole business community. So the tone and tenor has been decisively very proactive, very respectful. It is our hope. It is our hope, that we can find, a little more common ground, so we can move the chamber from neutral with some concerns to an actual support measure. We don't know, but we can say that that we have made tremendous ground together. We want to make sure we get to the point where we have enough teeth to actually fulfill the objective, but making sure that all of these folks who have had, and the number has been very clear, your chance is only 17% with a judgment on your side, that you'll actually even collect those wages. 83%, that's an atrocious number. We have to make sure we can meet our objective by getting these hard-earned wages into the pockets of these working families and do so in a manner that hopefully is not either A, onerous, cumbersome, or B, applied in an overzealous manner. So we're trying to be very strategic and surgical.
Are there any further questions or comments by members of the committee? Seeing none, do you wish any further comments to close?
No, with that, those will be my closing comments. I respectfully ask for an aye vote. Thank you very much.
Thank you very much. We'll go ahead and proceed with vote.
Motion is due pass to Judiciary Committee. Hernandez, Harper?
No.
Harper, no. Chu? Lowe? McCarty? Aye. McCarty, aye. Patterson? No. Patterson, no. Thurman? Aye. Thurman, aye. That bill is on call.
Okay, your bill is on call. Thank you very much for your presentation.
Thank you, members. Thank you.